Thank you, Rim. Can you hear me? Yeah. Okay. Um, I want to thank first for the invitation. I'm glad to be here. I'm glad also to meet Camila Vergara, to see friends and other people that I met in Palestine. I want to also apologize because I will be presenting a text that I had already presented in Palestine, but I have a good reason for that, and I think it's a very important topic that sometimes is somehow forgotten, and I think is of absolute urgency today. Since I was invited to speak in a conference about shrinking spaces and resilience strategies, I wanted to present again this text that advanced the idea, rather, I would say, provocative idea, and for some even irritating, the idea of international law and international human rights law being used today to actually not to expand the spaces of freedom for Palestinians, but rather to shrink them, to limit them, and to act as a sort of disciplinary tool. More and more, we see that the debate and the discourse on Palestine is more and more frequently framed in the language of law, human rights, and international law more generally. And the presentation that I wanted to do somehow revisits what I would call the Palestinian turn to law as a main strategy for emancipation. So contemporary Palestinian politics is marked, I would say, by paradoxical dynamics. While we observe an entrenchment of the colonial regime, division within the national movement, territorial and institutional fragmentation, and heightened authoritarianism, we also witness a growing reliance on international law, the language of the rule of law, good governance, and human rights. The paradox, I would say, lies in the fact that despite law playing a central role in furthering these colonial dynamics, Palestinian and pro-Palestinian groups increasingly translate their political claims into legal language as their primary site for the pursuit of an elusive political emancipation, producing what Foucault would call a discursive explosion in the juridical field in relation to Palestine. Everyone, or almost everyone today, when it speaks about Palestine, does it within the frame of human rights, international law, and law more generally. Now, this turn to law has, not surprisingly, I suppose, prompted a sort of further legalization of Palestinian politics. From the perspective of the Palestinian Authority, for example, a non-sovereign entity, but nevertheless highly legalistic in its action, this shift is extremely clear. And it is best reflected now by the PA's almost obsessive use of international law to frame Palestinian political claims. But also, ordinary citizens are turning to law and increasingly contest what they perceive as violation of their rights before PA and international judicial mechanisms, often, of course, with meager results. Similar dynamics occur within Palestinian and pro-Palestinian social movements, which persistently frame their political agenda within the language of law, particularly human rights and international law. Well, I would say, or allow me to say, that it's at least strange to see Palestinians, who have witnessed their dispossession and colonization organized, reified, and embodied in law, and their own authority using law to impose an additional regime of political subjugation, it is strange, I say, to see Palestinians placing so much faith in legality to achieve political emancipation. The problem is not so much the use of law per se, you see, which can obviously have an emancipatory potential. But what is worrying is that Palestinians seem to have uncritically embraced law as their main, and sometimes it seems their only strategy. One would think that when confronted with the impossibility of achieving their political objectives by other means, Palestinian and pro-Palestinian groups have experienced a sort of psychoanalytical displacement of desire, if you allow me to say, moving from real emancipation to the uncertain promises of law. Their discourse, as Judith Butler, paraphrasing Lacan, would say, constantly analogizes the lost object, in this case political emancipation, with the present object, the promises of law, and construct false certainties on the basis of partial similarities. Later I would explain, is not the same statehood than emancipation, right? The persistent resort to international humanitarian law in Palestinian and pro-Palestinian discourse is an excellent illustration of how seemingly liberatory mechanisms can also become technologies of their own domination. This legal corpus, international humanitarian law, entails a horizon which limits the debate on Palestine to the 1967 borders and the end of the occupation of the West Bank and Gaza. But it doesn't say anything about 48, the Nakba, the refugees, etc. It not only tends to exclude Palestinian refugees, but also casts out from the debate any reference to the Nakba and its continuous impact, imposing a solution of two states that, given the form of negotiations on Palestinian statehood, would certainly rearticulate the current political subjugation of Palestinians. And this formula imposes this problematic option even before we have had a proper debate about what a fair solution may look like, not only for Israelis, but for Palestinians, all Palestinians as well. These dynamics put into effect particular and very legalistic conceptions of freedom, equality, and emancipation, when what we need is to argue about the powers that need to be negotiated or defeated to produce a real emancipatory order for Palestinians. Some important works, critical actually, of this turn to law or highlighting its limits and dangers have been published by Palestinians and non-Palestinian scholars. They analyze, for example, the instrumentalization of the legal discourse and a certain political cynicism that it can produce, like Laurie Allen, for example. Or they also reveal how the Israeli juridical field reduces Palestinian political claims to legal technicalities, such as the nature of elements of proof and evidentiary burdens, excluding the political debate of the Nakba and its refugees, like in the work of Samira Ismail. Also, this work exposed the appropriation of the language of international law and human rights by conservative actors and state powers to shield their actions from legal accountability and reproduce structures of subjugation, like the work of Noura Erekat shows, or others that highlight the whitewashing, pinkwashing of egregious Israeli policies against Palestinians by resorting to a rhetorical affirmation of minority rights, gays' rights, for example, like in the work of Catherine Franke, or even more disturbing, these studies unveil Israeli settlers' work in framing their own situation as a question of law and human rights, like in the work of Nicola Perugini, for instance. However, I would say that for a complete diagnosis of the complexities, tensions, and contradictions that the turn to law implies, and beyond cynicism, beyond instrumentalization or appropriation, critical legal scholarship on Palestine needs to pay careful attention to the very logic that the turn to law imposes and its impact on Palestinian struggle for emancipation. We need to undertake a sort of, I would say, critique of legal reason, asking what law itself does, its language, its criteria, its assumptions, its structures, its practices, to our political claims. What does law do to our political claims? Some literature in other fields, like Indigenous First Nation studies in Canada, labor organizations, LGBT, and African American rights movements, identify some of the main problems present in legal logic and these movements' own shift to law. They show, for example, how, for instance, legal logic narrows or channels a movement's demands into terms that are recognizable to a liberal regime of rights while transforming their political substance and normative aspirations, or how the juridical field turns the affected communities into rights holders, increasingly concerned with legal technicalities and thereby flattening or erasing an analysis of relations of law and power and structures of oppression. These critiques also show how law generates an attachment by relevant communities members to a kind of injury recognized by right-based claims and the identities associated to them, wittingly or unwittingly reinforcing essentialized identity politics, or how law and the logic of law privileges precedent, causation, individualized harm, and other legal values over critiques of power structures, imposing a binary logic of winners and losers on the more radical, democratic, and richer debates and approach to socio-legal change embraced by movement actors outside of the legal context. This literature also explains how legal practices and structures facilitate the rise of elites, such as lawyers like us and other experts, to the position of leaders, who then shape the movement's goals in place of the expertise and goals of grassroots movements leaders. And finally, this literature, critical literature, also shows how legal language and legal discourse favors an uncritical assessment of the kind of victories that law can deliver, thereby obscuring the processes by which strategies of redress can become technologies of domination. Given this summary diagnosis, I think there is a space to ask, should Palestinians uncritically embrace legalism as their only or their main strategy for emancipation? by which logic does our claim for the liberation of human subjects becomes a discursive strategy for legal recognition? How does legality constrain our political aspirations and make us want what it promises but cannot deliver? What is the nature of the relationship between desire and law? How do law and its productive and legitimizing powers bring us to desire with such a force things like rights, institutions, regulation, statuses that are not only different from our original political claims, but that very often subvert them or are the exactly opposite of them? Take the example of Palestinian statehood. The obsessive insistence of the PA on being recognized as a state, and the astonishing number of ordinary people and political movements who fervently support this strategy, which is, again, eminently legalistic without necessarily changing anything meaningful on the ground. The obsessive desire for a statehood evidently has led Palestinians, the Palestinian leadership particularly, not only to be ready to accept something different from what they fought for, in this case, to accept pseudo-statehood rather than emancipation, but the problem is also that the state that they are negotiating when they were negotiating seems to be the exact opposite of what they originally wanted. Indeed, the Palestinian national movement was created and sustained by refugees, and it always defined its struggle as a battle not for a statehood per se, but for the liberation of Palestine and the return of its people to their land. Now, everything in the Israeli-Palestinian negotiations when they were taking place indicates that a potential Palestinian state will be built, if ever, on the very renunciation of the right of return. Well, this is exactly the opposite of what Palestinians were fighting for. So my conclusion is simple. I think we urgently need to seriously engage with the Palestinian movement's turn to law and its potential consequences for political emancipation. But my point should not be misunderstood. I tend to agree with Spivak when she says that rights are something that we cannot not want. Effectively, between a political order with rights and one without, my choice is clear. I prefer one with rights. So therefore, the aim of this analysis of my presentation is not to advocate for an abandonment of law and rights, but rather I propose to continue a necessary debate on the paradoxes, ambiguities, and traps that law offers, so that Palestinian strategies of emancipation effectively do not become technologies of domination. Thank you so much.